Good evening. Happy Tuesday. This is going to be a video about a way of approaching a legal problem. And we have two people who are both approaching a legal problem in the same way. We have this guy discussing law right here, who's an acolyte, or I don't know, he is a defender of Chillie. And we also have Chillie de Castro. So they both approach the law in the same way. Now, what they do is they have a problem, they have a thing that they want to defend, a position that they want to defend. So Chillie makes an assertion, and then he, or discussing law, wants to come in and defend that position. Whether the position is right or wrong, they're going to look for something to defend their position. We've seen it with Chillie. We see it with his little buddy discussing law. You may not know who discussing law is, so let me give you a bit of an overview. A few days ago, he did a video critiquing my video on specifically the complaint that Chillie made for defamation and what was the other thing? I forget the other causes of action that he had, but against Kate and Josh Abrams. Kate Peters is. So anyway, I found it to be a hilarious video. It didn't seem to get a very good reception from anybody else, and I don't think he meant it to be funny. But he also has such other riveting documentaries or series such as Facebook Class Action, How Much Am I Getting Paid? An hour-long diatribe. A two-part series on who owns the fence between our yards. How to sue a company like YouTube, service of process specifically. And Stay Right, It's the Law in California. A half hour on how to stay right, it's the law in California. 20 minutes on how to serve YouTube. That's ridiculously simple. But whatever, he has made these videos, and by God and by golly. So what are we dealing with here? This is a comment that he left on Chillie and perjury / passing the bar. Now I had discussed in the video that Chillie had signed his complaint under penalty of perjury. And I said he wasn't required to do it. You know, it's not fatal to his complaint. The court's just going to shrug its shoulders and be like, yeah, whatever. I mean, it's no attorney's going to be like, I object. I want to strike this complaint because he signed it under penalty of perjury. He did it. He didn't have to do it. That was my point. But this guy doesn't like Chillie he doesn't like people pointing out that Chillie does stupid shit that he doesn't have to do. And so he wants to defend it. His goal going in is to defend Chillie's position, to make it look like Chillie isn't a complete dunce. Dunce cap, I think is a word. Is it dunce cap? Playboy? I don't remember. Dunce cap. I'll go with dunce cap. It's something like dunce cap or dunce. Anyway, he wants to pretend that Chillie isn't a complete cretin when it comes to the law. So he says, hey, Merbeast, here's one explanation of why pro-per parties use a declaration. I'm assuming he means a declaration under penalty of perjury. McNeil versus Macht. And this is a FSUP case. So FSUP is always going to be district court cases. District courts can publish their cases. And they may be persuasive, but they're not binding. They're not stare decisis. So even in whatever district they're in, like this is an Eastern District of Wisconsin case from 1991, another court in the Eastern District of Wisconsin does not have to go by what this says, let alone anybody else. I think Wisconsin's 7th Circuit, I think. Don't quote me on that. I could be wrong. I'm not a trivia guy. I'm sorry. So it's just a thing. Just in case some other court has to deal with a similar situation, sometimes they'll publish it because they think they did a really good job, and it gets published in the FSUP. So, and he also says 28 U.S.C. 1746 is admittedly hard to infer from, and the history of pro se parties losing its summary judgment is not obvious. Let's unpack this. Have I said enough times to be Chillie? Let's unpack this. Let's unpack this, Playboy. Let's unpack this, Playboy. Playboy. Press a 1. Press 1 in chat. Press 1 in chat if you think this guy's a dunce cap, Playboy. So anyway, let's unpack this. He's suggesting here that McNeil versus Macht suggests why a party should sign their complaint under penalty of perjury. Because I'm assuming that in McNeil versus Macht, the plaintiff did not sign his complaint under penalty of perjury, and as a result thereof, lost on some sort of a summary judgment. Now, what is summary judgment? Summary judgment, for those of you who don't know, it's Federal Rule of Civil Procedure 56. We're going to go with 56. I saw it just recently. I think it's 56. Anyway, that's where the defendant says, hey, look, court, let's assume everything that they say is true. With the facts that you have, we still win. And if that's the case, then summary judgment. There's no issue of tribal. There's no issue of fact that still needs to be figured out. Assuming everything the plaintiff says is true, defendant still wins. Summary judgment. So that's what's happening. So I don't understand why he's saying this. Now, 28 U.S.C. 1746 is just the unsworn declarations under penalty of perjury. That just says that if you make a declaration and you sign it, I declare under penalty of perjury that the foregoing is true and correct, then the court accepts that as a declaration under penalty of perjury, and it's an assertion of fact, right? So I don't know why he put that in there. Is it admittedly hard to infer from? What do I have to infer from it? I don't know what he thinks I need to infer from it. And he says the history of pro se parties losing at summary judgment is not obvious. Pro se parties lose all the time at summary judgment because they don't know the important things to say and how to say them in their complaint. Even attorneys don't get it right all the time. And that's why you will often see attorneys doing first amended, second amended complaints. But the problem for him in McNeil versus Macht is not only is it an Eastern District of Wisconsin case, meaning it's not precedent, it's not stare decisis. In addition to it being old, from 1991, in addition to them having a local rule requiring all the complaints for 42 U.S.C. 1983 to be signed under penalty of perjury. And in fact, in this case, the pro se plaintiff filed on the form complaint, meaning it was filed and signed under penalty of perjury, and who later filed an amended form complaint, again signed under penalty of perjury. He still lost, at least in part, at summary judgment. And the court actually doesn't hold it against him. I mean, the problem that he ran up against, and the court was very lenient, was that when they filed their motion for summary judgment, let's see it. I think it's Rule 56, FRCP, Rule 56. So responding to it, you have to file affidavits and declarations. An affidavit or declaration used to support or oppose a motion must be made on personal knowledge. You have to give the court the things to survive summary judgment. Because what the defendant is saying is, hey, look, everything they pled, if it's true, we win. You need to give the court more things. Under penalty of perjury, there's also this. Court, consider this. And then the court can be like, okay, well, okay, maybe we need to go and try this case because there's these facts that, if true, are going to prevent summary judgment. So what he did is he did a few seconds of research. He found something where someone signed a complaint under penalty of perjury. And here you go. Now, for those of you who aren't aware, Rule 8 says that a pleading that states a claim for relief must contain a short, plain statement of the grounds for the court's jurisdiction, a short, plain statement of the claim showing that the pleader is entitled to relief, and a demand for the relief sought. And it doesn't have to be. It doesn't have to be under penalty of perjury. In addition, Rule 11 says representations to the court by presenting to the court a pleading, by presenting, not signing, by presenting to the court a pleading, written motion or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies it to the best of that person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, that the factual contentions have evidentiary support, or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Just by presenting it. So, for example, typically this would come up with an attorney. If an attorney signs it, then he is presenting it to the court. If the attorney files it, but he doesn't sign it, like if two attorneys are working on it and one attorney signs it as a lead attorney and the other attorney files it, he's certifying by filing that it's to the best of his knowledge that it's true. Later advocating for it. You'll see that with attorneys. If you come into a case and there's a bullshit complaint, you've got to correct it. If you later advocate for that bullshit complaint, you may get sanctions. See, sanctions are what you get. You don't get perjury charges, you get sanctions. I know a lot of people are like, oh, if there's no perjury, then everybody can just do whatever they want. No, there's sanctions. I mean, the court can still discipline you. And then for whatever else he has left on this, Twombly and Ashcroft versus Iqbal, Bell-Atlantic versus Twombly and Ashcroft versus Iqbal, both of which are post 1991. They say that Rule 8, interpreting Rule 8, as long as, for a summary judgment or a motion to dismiss, or 12b6, that's what they're looking at, 12b6. They don't have to, it doesn't have to be signed under penalty of perjury. What it has to be, the court has to assume every allegation in the complaint is true. Assuming every allegation in the complaint is true, if despite that, the plaintiff still loses, then the plaintiff loses. So if you're doing a 12b6 or some other motion like that, the court is going to assume that the complaint is true. Every allegation in the complaint is true. I know this is a slight, dumbing down of the holdings of Twombly and Iqbal, but that's essentially it. That's the important thing for what we're doing. So he's wrong. And then we got Chillie. Now Chillie's done a lot of weird things that I don't understand. One thing that Chillie does is Chillie likes to point out trivia. Chillie has substituted trivia for understanding. Chillie will tell you Rufus Peckham is the guy who wrote the holding in 1900. And yeah, I mean, Rufus Peckham is the guy who wrote it. And it was in 1900. So, that's awesome. I mean, that's great trivia, right? We're talking about Bad Elk. And then you're like, okay, cool. Maybe you know something. But he just knows trivia. He doesn't understand the holdings. He doesn't understand them. He says Peckham is on here. Rufus Peckham is the guy who wrote the holding in 1900. His head actually covers up the holding of Bad Elk versus the United States. And what Rufus Peckham said in the holding is that you are not allowed to resist police. There will be no resisting police. That's what Rufus Peckham said. And that holding from 1900, Bad Elk versus the United States, is still law today. Rufus Peckham, you are not allowed to resist the police, comes from two Native American Indians who shot each other, that both have assimilated. They went through the same culture, yada, yada. Now, Bad Elk versus United States. John Bad Elk was a Indian policeman, and he ended up shooting somebody. And the other police wanted to talk to him about it. And he's like, yeah, I'll come in later. And so then they went to arrest him. And a guy who's ironically named like Fires Back or Shoots Back or Fights Back or what the hell's his name? John Kills Back. His name was John Kills Back. John Bad Elk killed John Kills Back. And John Kills Back didn't kill John Bad Elk back. Anyway, so what normally you see Bad Elk versus the United States cited for is the proposition that there is a common law right enshrined by the Supreme Court. The Supreme Court says you have a common law right to resist an unlawful arrest, because indeed the court found that the court clearly erred in charging that the plaintiff in error, John Bad Elk, the defendant, had no right to resist an unlawful arrest. Or an arrest that was using excessive force, I should say, to be more correct. So, into common law, if a party resisted arrest by an officer without a warrant, and who had no right to arrest him, and if in the course of the resistance the officer was killed, the offense to the party resisting arrest would be reduced from what would have been murder if the officer had the right to arrest to manslaughter. It would have been murder if the officer had the right to arrest. If the officer had the right to arrest to manslaughter. So, where sovereign citizens go wrong is they're like, okay, so in this case, common law, that means that common law is everywhere because the Supreme Court said it's the law of the land. And so everybody has a common law right to resist an unlawful arrest. What they don't understand is the context. What's going on here? Why did this get in front of a Supreme Court in the first place? The Supreme Court is not interpreting the Constitution or a federal law, right? They're saying 3 policemen in South Dakota attempted under verbal orders to arrest another policeman for alleged violation of law. So why is the Supreme Court involved? The Supreme Court doesn't have jurisdiction over state law issues. The states have the right to have their own law, and the state Supreme Court is the ultimate arbiter of what state law means and whether or not you have a common law right in that state to resist arrest. So why is this in front of the Supreme Court? It's in front of the Supreme Court because these are Indians on Indian land. And Indian land at 1900 didn't have all of the current laws in what are those? 26 CFR something or the other? Hold on a second. 26 CFR. I don't know the rest. It's 26 CFR. No, it's not 26. What is Indians? 26 USC is Indians? No. $25. Jesus. 25 CFR. See, I'm not the smartest boy in the world. I'm just going here I don't want this. I want Cornell. There we go. All right. Bureau of Indian Affairs. And then I want it's tribal government. They have like basically model penal code for Indian tribes who don't have other laws governing law and order. Law and order. I think it's this one. Yes, Indian offensive. Okay, Indian offenses. All right, so these didn't exist back in 1900. There was not the 25 CFR subpart D criminal offenses. Sorry for the detour. So the court is like, well, what do we do? And what courts default to, if there is no statute, if there's no other rule in place, is they default to common law, because our law derives from English common law. So that's what existed when we set up our courts. Our courts, there were courts in the colonies that were judging things based on English common law, and then the rebellion happened and they just kept that. And because there are situations where something's right, something has to happen, and so the court's like, we're just going to default to the common law. And each state has built up their own common law. Indian land, tribal land, when it didn't have a law, it goes to a federal court, and the court's like, I don't know what to do, right? So the court's like, well, common law. We're going to use a common law. But now there's statutes. So the court doesn't need to resort to common law because they're now statutes. And a state is not an Indian reservation. Indian reservations are controlled by Congress. Congress has the right to control Indian lands. And so even if that land is in a state, Congress has the right to control that land. But outside of that state, the state has the right to, or outside that Indian land, the state has the right to control it. And so this particular ruling by the Supreme Court will not affect a state's law. It won't make a state apply this particular bit of common law. And most states have statutes on whether or not you can resist arrest. So, check with a local attorney. But his assertion that, and I also did a video on Bad Elk is Bad Law. It's called Bad Elk is Bad Law, if you want to watch it. I'm resolving the issue. You notice this is from, is this from LexisNexis or is this from Westlaw? I don't remember, but it had a little stop sign. And Lexis, yeah, this is LexisNexis. Little stop sign saying, warning, this is bad law. So anyway, the court certainly didn't say that you're allowed to, that you're not allowed to resist police. It certainly did not say that. It in fact said the exact opposite of it. But that's what you get when you focus on the trivia and you memorize the trivia, but you don't understand the holding of the case. I remember, just a quick story time. I guess nothing's quick because I talk slow. But I remember I graduated from law school, and I'm going to get this wrong. It was either 2000 or 2002. I don't remember which. Sue me. It was a long time ago. And I was in management until 2016 when I decided that, I want to be a lawyer. And I bought a book off of, to study for the bar. I bought a book off of Amazon. And I started reading this book. And I realized I didn't know a damn thing. None of the concepts made sense to me. And so I understand. I've been where you guys might be at. Some of you know more than others. I've been there. And these concepts, they seem like they're in isolation. And why do you get that out of it? Why do you know if that case is bad and that case is good? And it's hard, and I understand it. And it wasn't until I signed up for a bar study class, I think I got the book in like June or July, and I read it all the way until I started, it wasn't Barbary, it was, I forget the name of the study course that I used. But they started in like late November. And all of a sudden, like having people explain it to me, hearing it, and having them kind of go over it in layman's terms made it start to make sense. And, thankfully I was able to pass the bar at my first attempt, but studying for it, it's hard to get some of this stuff. It's not easy. I work with lawyers who sometimes don't get it. Lawyers who've been practicing for 50 years and don't get it. A lot of the language that's used in law it doesn't mean exactly what it means in normal English, in common parlance. So you got to be aware of that, and it's hard. So if you don't understand it, don't beat yourself up. If you have questions, feel free to ask. I try to respond. A lot of times, like if I don't have the information, if you want something specific about a specific thing, hard to do. Hard to get all the facts. But I try to respond as best I can in the comments. If you have questions, let me know. Thanks for watching. Have a great day.